Murugara has raised very fundamental matters, but I'll allow a few others to weigh in. And I will definitely start with the Honorable Otiende Omollo, followed by...
Thank you, Mr. Speaker. Mr. Speaker, I see Honorable Kaluma eyeing me badly, but I will have him know that my right to raise a point of order was actually reserved by the Speaker on 29th of September when this matter first came for the first reading. And I did indicate to the substantive Speaker that I had certain constitutional concerns, and the Speaker directed that before commencement at the second reading, then we would raise them. And therefore, I joined the Honorable Murugara in raising constitutional issues. I will not repeat the parts that Honorable Murugara has covered. And Honorable Murugara has covered clause 9B and clause 2B. And he has cited the issue of discrimination and the legal principle of advocate-client confidentiality. Mr. Speaker, I will only point out further clauses that also fall within that category. But to cap clause 2B, this bill, amendment bill, proposes to include advocates as reporting agents. And the first question to be asked is why only advocates in addition to accountants? There are many professions that receive money, and there are many professions that deal with money. If it was a question of dealing with professions, then it would have been dealt with the way already now the Act deals with it. If you look at the Act, the Substantive Act, Section 2G, it allows the minister discretion to add such other business or professions in which there's a risk of money laundering, exists, as the minister may, on the advice of the center, declare. It is broader, and it invites the possibility that there must be a demonstration. But if then you want to focus on advocates, then you must demonstrate why is only advocates being included. That is discrimination. Mr. Speaker, it is not only discriminative of advocates. Even when it comes to its own definition, it has further discrimination within advocates in two ways. One, it only talks of advocates, notaries, and what it calls independent legal practitioners. It introduces a term not known to our law. That term is not in the Advocates Act, is not in the Law Society of Kenya Act. Whatever it is, we don't know what it is, and it is not defined in the amendment. Independent legal practitioners, we don't know who they are. But also, in its conclusions, in definition section 2, it talks of advocates, notaries, and other independent legal practitioners within professional firms. So again, it only restricts the advocates who are within professional firms. So it's discriminatory of advocates generally, and then even within that category, it only refers to those within professional firms. Mr. Speaker, it is interesting to note that in the definition of the reporting agents, the advocates are now supposed to join others like operators of casinos, estate agents, dealers in precious stones, and such other businesses which ordinarily do not come with grace.
The Honorable Otiende, which clause are you referring to? Can you read it, all of it?
I am reading the definition in clause 2B in conjunction with Schedule 1 of the Substantive Act. If you read Schedule 1 of the Substantive Act, it already enumerates the reporting agents. Those reporting agents, you will see, Mr. Speaker, include operators of casinos. It includes, dealers in precious stones, estate agents, and such other profession. Now, the advocates are now supposed to join that hallowed list. And it is quite telling, Mr. Speaker, for a profession that is usually described as noble to be put in that category. Mr. Speaker, the fundamental point is, other than being unconstitutional, is it necessary? If the intention is to give an authority to include any other profession, once it can be demonstrated and justified, then it already exists in the Substantive Act, in Section 2, as I referred to, G, which gives the minister on the advice of the center. But in including the lawyers, then now it does not depend on advice. It does not depend on anything. They are just included. Mr. Speaker, Section 9B is a section the Honorable Murugara did not mention, and I want it included in that consideration. The issues are as similar as the issues in Section 2. Then clause 10, C, 3A. Again, when it comes to qualifications for appointment, that is also to be considered. But of greater concern is clause 130A. That is the limitation clause. That is the clause that now limits the right to privacy in Article 31, and I'll come back to that. But as clause 130A talks of the limitation, clause 131 and 2 then gives that limitation and gives a discretion to be searched, for seizure of property, to reveal financial information of family, not even of the advocate, of family. And it also allows interference with communication without due process. There is nothing in this amendment that talks of any due process. And so you now want to subject advocates to the possibility of seizure, search, disclosure of financial information of family, and even communication without due process. That is unconstitutional, Mr. Speaker. Mr. Speaker, clause 16.1 then brings in the Law Society of Kenya as one of the other bodies, what is called supervisory bodies, without examining the capacity of the Law Society of Kenya to be a supervisory body in financial transactions. The Law Society so far regulates who can practice law, not how. Who can practice law, not how. And in doing so, it then now requires the Law Society to do two further things. One, under Section 44 of the Act as it is now, then it places an obligation to start monitoring lawyers in terms of how they do their work. And in terms of Section 45 of the existing Act, it then places an obligation on the individual advocates to verify customer information. And such customer information is indicated as identity, including birth certificate, including driver's license. Those are the kind of things that now this proposal wants advocates to do. Mr. Speaker, it is not only discriminatory, it is burdensome, and it infringes on the age-old custom of client-advocate confidentiality. Turning to Article 31, Mr. Speaker. Article 31 of the Constitution is very specific, and it protects privacy. Under Article 131C, information on private affairs. Under D, privacy of communication. In this bill, the bill specifically seeks to bring information on family under Clause 130, communications under Clause 132. And Mr. Speaker, it is to be noted that Article 24, Subarticle 5, tellingly allows limitation of the right to privacy for members serving in the KDF and the National Police Service. Why does the Article 24.5, take the trouble to say that for the right to privacy, for those in the armed forces and the disciplined forces, it can be limited? It is because the right to privacy is fundamental. It may not be non-derogable as those in Article 25, but it is fundamental. You cannot just derogate it. Mr. Speaker, if you look carefully, and I now come to Article 24, if you want to limit the right to privacy under Article 24, you must do at least three things. First, you must limit it by law, as they are seeking to do. Secondly, that limitation has to be reasonable. And it has to be reasonable in a democratic, it must be reasonable and justifiable in an open and democratic society. I have read the entire bill, the purposes, the report. It does not seek to demonstrate the justification in an open and democratic society. Mr. Speaker, it might look easy, and one might say it concerns lawyers. Let it be remembered that the confidentiality of the client-advocate confidentiality is not for the benefit of the advocate. It is for the benefit of the client. So when you look into it, it is not the lawyers it's affecting, it is everyone else. Might it be remembered, Mr. Speaker, that as we seek to curtail and diminish the standing of the legal profession in this country, we are members of the East African community and members of COMESA. The constitutive instruments allow cross-border practice. We are coming to a situation where we are diminishing client confidence in advocates in this country, with the result that they will just use other practitioners in other sister countries. Mr. Speaker, I want to suggest that even as we lose on this issue, it should be remembered that already we have very stringent regulations, both under this act and under acts, where any professional, not just advocates, who deal with any bank are required to disclose information when you receive money, when you send money, and that is sufficient. There can be no justification for now isolating and bringing the lawyers to this. Mr. Speaker, I want to submit that this proposal, however well-intentioned they are ill-advised, they are ill-conceived. The text is such that it cannot pass constitutional muster. Indeed, Mr. Speaker, rather than have long debates on this matter, Mr. Speaker, I urge you and the substantive Speaker to find that these proposals are completely unconstitutional and to be dropped at this stage. Thank you, Mr. Speaker.